matter in the case that you didn't mention, as far as I could detect in that, is the fact that the initial operative instance of the law is predicated on the idea that the curation is occurring abroad. So it's a foreign entity abroad who's engaging in the curation that's causing the content manipulation.
We're watching it
you
on
highlighted.
YouTube. If you guys want to join,
how does that factor into the analysis from your perspective? Because I think that the government's point is,
jump into my
sure,
server.
you've got your point about content moderation,
here,
content manipulation.
So they are in the middle
that comes up in a lot of cases, including in net choice in the Supreme Court. But this case is different because it involves something that's happening abroad. And what we're worried about is the effect of something that happens abroad. And when it's a foreign organization, they don't have a First Amendment right to object to a regulation of their curation.
Well, a couple of answers to that, Your Honor, if I can walk through them. I think the first step is TikTok Inc. is a U.S. entity that engages in speech. It curates third-party content, just as the net choice, and it engages in its own speech. So the speech here that's being banned, we would say, or at the minimum burdened, is the speech of a U.S. speaker. I think the government tries to argue that because TikTok Inc. ultimately has a foreign owner, that somehow affects whether TikTok Inc., the U.S. entity, has First Amendment rights. That can't possibly.
I don't think they're arguing that. I think what they're saying is TikTok Inc. may well have First Amendment rights and does, but TikTok Inc. can continue to curate to its heart's content. But what it can't do is do that while it's owned by China, because we're worried about what China does vis-a-vis TikTok Inc.
Okay, well, I want to get to the bottom line of Your Honor's question, but I want to correct the premise. It's not owned by China. The owner of TikTok Inc., it's ByteDance Limited. It's a Cayman Islands holding company that's owned by
subject to Chinese control. They're subject to Chinese control.
Well, they argue that, but I think the critical issue here is what they're saying is because there is the possibility of future Chinese control, right? They don't claim anything has happened yet. They claim there's future Chinese control, and therefore we can burden in a very significant way the speech of a U.S. entity and its users, which by definition is fully protected speech. So in order to say that they can do that, essentially take away the speaker rights of a U.S. entity, they surely have to meet strict scrutiny. So even if the court concludes that the foreign government manipulation is not subject to the First Amendment, and I think there are questions about that. No court has held that. The most that the United States has ever done before is to say that foreign speech has to be labeled. But I don't think the court
isn't that what the Supreme Court said in USAID?
I don't think so, Your Honor. I think what USAID said is the speech outside the United States by non-US entities is not protected. So there were two elements there. They aren't here. We're talking about speech in the United States. But as I say, even if the
I'm just saying if the curation that's being worried about is the assertion of control by the Chinese government in China, then that fits within the USAID.
I don't think so, Your Honor, because it's still speech coming to the United States. I think it raises a complicated question that courts really haven't addressed. But as I say, I don't think the court has to go that far, although we advocate that. I think the court, what's clear here is the burden of the government saying because of this indeterminate future risk, we can impose burdens on speech that there's no dispute is 100% protected by the First Amendment. That requires strict scrutiny.
Mr. Hunkus, what is the best evidence that TikTok US or TikTok Inc. is engaged in its own expressive activity that's not controlled by ByteDance?
Well, A, it's a U.S. entity. B, we have in the
it is a U.S. entity. Right?
It is a U.S. entity, and open society essentially establishes a presumption that we respect the corporate form. The government is not arguing that there's a sham here. So I think that's the starting point, but I think the record also makes clear that the curation occurs in the United States. The record is clear.
The presser declaration?
Sorry?
The presser declaration?
The presser declaration, exactly, Your Honor, at pages 799 to 800 and 812 makes clear that content moderation occurs in the United States, and there's no dispute that the TikTok Inc.'s own posts are in the United States, its own speech. And of course, there's a lot of US user speech that is on the platform. So I think all of those things together combined to say there's no showing here and no argument here that there's some kind of a sham with respect to the content moderation that's occurring now. The government's argument is something might happen in the
Even
future.
if there's not a sham, I mean, what about our case from 1988, Palestine Information Office? Are you familiar with that case?
I don't think I am, Your Honor, unfortunately. I apologize.
The government doesn't cite it, which I was a bit surprised about, but it's a case from 1988, Judge Mikva, joined by Judges Starr and Silberman. And there, I think this circuit essentially said that the fact that the Palestine Information Office, which was an entity in the United States, could be shut down by the State Department in part because of its affiliation as a foreign mission of the PLO, which is a designated terrorist organization. And our circuit seemed to suggest very strongly that the control or the relationship itself was part of the strong justification for what the government did.
Well,
If you're not familiar with
I'm
that
not
case,
familiar with
then-
that case, Your Honor. Happy to address it in a supplemental brief, but I think even from Your Honor's recitation of the facts, the government isn't arguing here that there's control now, either by China or by ByteDance Limited. I do think, just stepping back from China and talking about Your Honor's question about whether foreign ownership by itself could be
Justice
enough.
Barris suggests that this might make a difference in her separate opinion in Net Choice.
She did, Your Honor, but
Just one
it
justice,
would
but
really have quite far-flowing ramifications, as we talk about in our brief. There are lots of U.S. speakers, Politico, Business Insider, we talk about Reuters, we talk about a lot of them in our brief that are owned by foreign entities.
but not
And-
foreign adversaries.
Well, I think the question, I don't think that affects the First Amendment question. That might affect strict scrutiny. So I think it's very important in this case to take things in stages. Are there protected rights that are burdened? Does that burden trigger strict scrutiny? And then we can look at the justifications and see if they hold up. But I think at the first stage, are there First Amendment rights that are being burdened? Even the government doesn't argue that TikTok Inc. has no First Amendment rights. They make this brief argument about foreign ownership making a difference. But as I say, mere foreign ownership can't possibly be a justification because it would turn the First Amendment on its head. We have lots of publications that are owned by foreign entities, and to say your foreign ownership casts your First Amendment rights into doubt, or in a defamation case or a government regulation case, it's open to explore the interactions between the foreign owner and the U.S. speaker to see precisely what speech is controlled and what's not, would really fundamentally change First Amendment analysis in a lot of issues. And it's what Open Society rejected. Open Society basically said, we're going to presume that there is corporate separateness. It may be that in that case, there was a showing of control that was satisfied. But here, there's no showing, certainly that ByteDance Limited is, which as I say-
Well, it's interesting because in that case, the court defers to the fact that the government thought there was foreign control. But in any event, so even if we assume that TikTok US has First Amendment rights as a US corporation, why wouldn't we apply intermediate scrutiny? Because the act itself, arguably regulates both, conduct, which is foreign ownership, but also, incidentally burdens the expressive activity. I know you won't, accept that characterization, but is that wrong?
I really don't here because a couple of reasons. I think what was clearly targeted here was the TikTok platform, a speaker. And I think when an individual speaker is targeted by a law, courts have said that that's enough to trigger strict scrutiny. I mean, News America stands for that proposition. Once the court concluded in News America that the law targeted only News America and wasn't going to apply to anyone else, it went right to heightened scrutiny. Now, in that case, the heightened scrutiny was intermediate because it was the broadcast context. But I think the analogy fits here. And Citizens United gives the reason for that distinction. It makes clear, what it says is there's such a risk of content and viewpoint-based discrimination when you target a specific speaker that we have to apply strict scrutiny. The second reason, the justification here is viewpoint. And so that by itself, Reed says, triggers strict scrutiny. But I want to go back to just answer one more answer to your prior question, which is, you said in the Palestinian case, there had been a determination. We don't really know what was determined here because this was Congress enacting a statute that has no findings. It doesn't say why Congress did what it did. It targeted TikTok. And the record here indicates that although the government says future covert manipulation by China is the risk, is the justification, the record is certainly not that clear. And
We've never held that Congress is required to enact findings in order, I mean, in some sense, the finding is the fact that they passed a law under Article 1, Section 7, designating TikTok for this treatment. I mean, it's not, there's no requirement that Congress needs to put in a statute its findings.
Totally agree, Your Honor. There's no general requirement, but I think as the court, it is not the APA. But that's part of the problem in this statute. Just to, I guess, two answers. The problem here is the statute doesn't say, and it's not a statute that sets up a general rule where you can sort of say from the general rule. Usually what happens in this, in the enforcement context, is Congress sets up a general rule. Facial challenges are hard because the general rule has some principles, and the applications occur in enforcement actions by the executive branch where there are specific findings and specific a basis to judge what happened. That didn't happen here. And the record, to the extent we want to go beyond the words of the statute, which as you say, just say TikTok, it doesn't say why. Looking at the record is suffused with much broader content justifications than the one the government tries to supply out.
So on the content modification rationale, there's another rationale too. There's the data security one. And let's just assume for present purposes, I know you resist the assumption and I can understand why, but just for hypothetical purposes, let's just assume the law was only undergirded by the data security rationale. So the content manipulation, the concerns about content manipulation just drop out. If the law was only undergirded by the data security rationale, do you think strict scrutiny applies?
I think it still does because it's targeted a specific speaker. If a law singled out the New York Times company and said, you're going to have to meet special workplace safety rules or special overtime rules, no one would say, oh, we're not going to apply strict scrutiny because there's a justification for workplace safety. There would be a significant argument about whether.
And the specific speaker is TikTok US.
Yes.
That's what. So but I think what the government would say about that, and we'll hear from the government, but I think what the government would say is we're not targeting TikTok US, quad TikTok US. We only care about TikTok US to the extent that it's subject to Chinese control. And so TikTok US can continue to be TikTok US full bore as long as it's no longer subject to Chinese control. And the way that that happens is to have a divestiture. But apart from that, TikTok US is totally fine with us.
But I think, Your Honor, the problem is, I mean, I guess we have two answers to that. One is divestiture is infeasible here for the reason that Professor Milch indicates. And so this isn't just about divestiture, it's really about a ban. But even if there, in some theoretical world, divestiture would be possible, there's still a burden on TikTok US. It costs, different speech is required. The statute says you can't bring in the foreign user content that is a critical part of TikTok. Your speech would have to be different. You can't use this recommendation engine. That would make your content moderation different. So, and the costs of divestiture by themselves are a burden on TikTok Inc. But just the kind of burden that Minneapolis Star and other Supreme Court cases have said triggers strict scrutiny when you single out a speaker. So
can I ask you this question then? If under your rationale, suppose the United States is at war with a country, and then there's a question about whether that foreign country can own a major media source in the US while the war is going on. Is your submission that Congress can't bar the enemy's ownership of a major media source in the US?
I think we would still be in the world of strict scrutiny. Maybe that would be a sufficient justification. But I think we would still have to look at those rationales and decide that they were sufficient. And, you know, when you're at war, probably they would. But that's a couple of things to say here. That's certainly not the rationale that they're giving. And just to sort of finish up my answer, I think in the divestiture context, we still have a burden on the US speaker's rights. I just want to return to your data privacy question, because I also want to say it would be impermissible for the under-inclusiveness reason that we cite in our brief. The statute, if you look at the broad statute, I mean, it's singling out TikTok is pretty under-inclusive by itself. But even if you want to consider the broader statute, there's an exclusion. It only applies to sites that host user content. There's the business review exclusion that we claim we have a little dispute with. The plain language seems to say if you're a company that has a business review app, then you're entirely out of the statute. But even if you read it the way that's certainly a shocking content-based distinction that undermines the data privacy interest. But even if you just read it as business, having a business review app by itself is excluded, those exclusions exclude e-commerce sites. And as we say in our brief, there are various e-commerce sites based in China and other places that collect much more data than TikTok does, very sensitive data. The record refers to one of them that was cited by a US commission as a possible danger, and they're categorically excluded.
So I just want to understand the implications of your positions, and we're not at war. I'm not suggesting that we are, but just to understand how the way you view the case would play out. If we were at war, if the United States was at war with, say, China, and what the law did was to bar Chinese ownership of, say, ABC, because China wants to buy ABC, and Congress and the national security establishment is worried about the repercussions of that. And so says ABC can continue to be ABC to its heart's content. The one thing it can't do is be subject to Chinese control in a time when we're at war with China, because we're worried. Because if China's in control of it, then it could engage in content manipulation of a type that's going to be problematic vis-a-vis US interests. Your view is that strict scrutiny would apply to that. Yes. And the government would have to.
Let me say, your example is ABC. That's the television network and its licenses. That's a slightly different world. But let's just assume it's someone who's not being regulated because of their broadcast.
Got it. Okay, right. Take the broadcast. I take the point, but a major media source. And then
I think strict scrutiny would be the question.
Under strict scrutiny, one of the points that you've made repeatedly and understandably is that the concern here appears to be directed at something that could happen in the future, not something that's necessarily happening now. So let's just say that that's true in the war context too. There's no particular reason to know what's happening right now. It's a concern about the future. Would that necessarily mean that strict scrutiny is unsatisfied? And so therefore...
I think it would depend on the facts. It might depend on the facts regarding the ownership. I think there are a couple of questions embodied in your question. One is whether this is a sufficient compelling interest. Even if it is, there's a less restrictive means question. And I think a critical point that we make, and that's true throughout the law, is the government's solution to foreign propaganda in every other context has been disclosure. It has not been a ban. The Mies case talks about that, and in footnote 15 has a very sort of fulsome and explanation why, that our view in America is if speech is made clear, then Americans can decide, and the answer for speech is more speech.
The disclosure idea might depend on the voluntary cooperation of the very control that you're worried about.
Well, I don't think so, Your Honor, because I don't know what the disclosure would be. Obviously, the government would have to show the predicate of the risk of Chinese control.
And you'd have to know that the manipulation is going on, right? Because to just...
Well, the government, in a hypothetical world, maybe, I guess this is how I think the process would proceed. The first question would be, is this a sufficiently compelling interest? And, there really isn't a precedent for a court finding government regulation of protected speech, which is what's going on here, because we still have a lot of protected speech, in a general sense, is a compelling interest sort of ever. So that would be a pretty shocking and big step. But assuming you could get over that step, then I think the next question would be, is the risk of control, since we're talking about the future, imminent? And I don't think imminent here, that's the word that Holder and Pentagon Papers use. And I don't think that's necessarily imminent in terms of happening tomorrow. I think it's imminent in the sense that the government is arguing here, which is that China could do this at will. That's our risk. China could do this at will, so we have to act now. And I think that has to be shown as a factual matter. And I think that would require, just sort of working through this case, the court to delve into the factual record and see if that's true, given the protections that are in place and the less restrictive means protections that we argue could be in place. I mean, we don't want our content. TikTok Inc. and ByteDance do not want the content to be controlled. That's why they've not only negotiated the national security agreement, it's why they've implemented it voluntarily, including a number of provisions that go to this issue. So the government have to show imminent in terms of China being able to do it at will, notwithstanding the possibility of technological protection. And then the question would be disclosure. And I think the government, if it met those tests, would then have to come forward with a possible disclosure. Zouderer sets the test. There's a compelled speech element, but that's what the government has done in other contexts where there's disclosure, movies, television, printed material. And I think net choice sort of points the way that for the government to say that disclosure won't work here requires some quite dramatic showing, because the court's general approach is to say, we treat these media the same. Now, maybe in some hypothetical world, the government could show that, but there's nothing in this record. And I think the critical thing, again, we're looking at a statute.
Is your argument, though, then, that if the government is concerned about covert influence by a foreign adversary, it has to, disclosure is always the least restrictive means? I mean, that would seem to me quite a remarkable determination to make.
Certainly,
for this
Your Honor,
court, under Holder and other precedents.
Well, it certainly would have to show that a reason why it isn't a least restrictive means. And remember, the actor here is Congress, and Congress didn't even, as far as we know, consider disclosure. And Sable and Playboy Enterprises say Congress has to consider less restrictive means. And so for that reason alone, there's a problem. This course is invalid. Whether the government could in a hypothetical case where there was actually a reasoned decision record, say we've looked at disclosure, here are the possibilities, we've actually concluded it doesn't work.
Sure. I mean, if the concern is data protection and covert influence by a foreign adversary, how would disclosure be, disclosure, if you're, under your view that like the only reason for this law is propaganda, maybe disclosure addresses that, but that, the act is not even aimed at expressive activity directly, it's aimed at foreign ownership of a U.S. corporation.
Well, just to take your last point first, as I said, Your Honor, we think it is aimed at expressive activity. The entire the justification relates to expressive activity. It singles out a specific speaker, and the whole debate. The Justice Department went up to Congress and said, at a minimum, though,
this act regulates both. Say it regulates expressive activity because it directly targets TikTok US, but it is also regulating foreign ownership, which is a separate non-expressive interest of the government. So with those combinations, why shouldn't we apply the O'Brien framework, for instance?
Because this is not a statute that's generally regulating foreign ownership. It's regulating foreign ownership. The provision we're talking about, foreign ownership only of a particular speaker. O'Brien was upheld because the law there regulated a whole range of activity, the court said, and incidentally, it might fall on speech. Here, the regulation falls directly and the burden falls directly on a speaker. Whether you think of it as divestiture or as a ban, the burden falls on the singled out speaker, and that distinguishes from O'Brien and Arcara and all those other cauld you think
you lose under O'Brien?
Excuse me?
I mean, you're resisting O'Brien of course you'd rather have strict scrutiny, but would you have an argument under O'Brien that
I think we'd still have arguments under O'Brien. I think the same arguments we're making, I think would be strong enough, but I don't think I think the government mentions these.
Because one of the criteria under O'Brien is whether the law is related to the suppression of free expression.
That's why we get out of O'Brien, right? Because it's a law related to the suppression of expression. That's what Texas.
That means that O'Brien's not satisfied. It doesn't mean you get out of O'Brien. That's what happens in net choice. I mean, that's one of the criteria under which a law survives O'Brien scrutiny. And your argument would be, I would assume, that the law can't survive O'Brien scrutiny because if it's related to the suppression of free expression, then it's invalid.
Yeah, I mean, I think we're just talking about a doctrinal difference here. I think the law is out of O'Brien and subject to strict scrutiny because it's not incidental.
Mm-hmm.
If I can just go back to Judge Rao's.
Hey, before you do that,
sure.
You earlier on said that curation would occur in the United States under TikTok's NSA proposal, correct? And the NSA proposal is more or less reflected in Project Texas, is it not?
Project Texas has implemented some, but not all of the protections in the NSA.
And the curation, the instrument of curation is the so-called recommendation engine. Is that correct?
There are multiple forms of curation, Your Honor. Some are content.
Is that one of them?
That is one of them, but not the only
one.
So
here's a little later in the Presser Declaration. Project Texas contemplates that source code supporting the TikTok platform, including the recommendation engine, will continue to be developed and maintained by ByteDance subsidiary employees, including in the United States and in China. So the curation is not entirely in the United States.
Well, I guess a couple of answers to that. First of all,
One will do.
Okay, well, there's review of those changes to the recommendation engine in the United States, but the recommendation engine is not the only form of curation. In the United States, there are also changes made to how the curation engine, the recommendation engine works that are US specific. Those relate to the content, the community guidelines.
Insofar as the changes are originating in China, they would be subject to review before being implemented in the US, right? Review through the TTD USA.
They're not reviewed before they are implemented, but they are reviewed and subject to recall. But I think the critical point is those changes to the code are not the sole content moderation activities. The US recommendation engine also takes account of determinations about what is acceptable content in the US, how should that content be treated. Some content
But in order
is
to
out.
apply what you just said, they have to look at what's coming down from Beijing and decide whether it comports with what's acceptable in the US.
Well, some of what they do is just done in the US. It's true that the source code, but I think Your Honor's point, I guess I just have to say, there are many US companies that have, that use source code that's developed in China. The Weber Declaration talks about that in detail. So the mere fact
Do any of them involve apps that reach whatever it is, 1 million people a month?
I'm sorry?
Do any of them involve apps that reach 10 million people a month?
Yes,
In the
so
US.
many of them.
Why is there no other, why is it, I could not find, because in any of your, the briefs, indeed in the declarations and so on, any reference to another company that would be subject to the second procedure provided in the statute, the alternative procedure that ends with a presidential determination?
Well, Your Honor, we didn't try to identify one, but certainly one of the reasons.
Well, you did assert that there were several, but, well, at least implied that by saying every other company would be subject to the second type of procedure. Is there such a company?
Well, I think we don't know what companies, Your Honor. I mean, I guess two answers.
Well, surely
One
ByteDance knows who they're.
Well, we don't know what companies the US government is going to say are subject to foreign adversary control. I think that's one of the problems with this statute, is that the US government could say, here is platform X. We think that they are subject to control by Russia. We're looking at their content. We think they're too susceptible to infiltration by Russia, and therefore they have to be moved to a new owner, even if the parent is a US owner, because that risk is too great. So we don't know what websites the government might argue, but I think the other critical question is, one of the reasons is the exemption of e-commerce sites. We do talk about two e-commerce sites that would certainly meet all of the other criteria in the law, but that are exempted because of the business review exception. Those sites, we don't know, but certainly those sites could well be susceptible to the government's action, but they've been excluded by Congress.
And that, with respect to your earlier colloquy, particularly with Judge Rao, I'm not sure if you did, but if you wouldn't mind again telling me why this is any different than from a constitutional point of view, than the statute precluding foreign ownership of a broadcasting license.
Because the court has said that that a lesser standard of scrutiny applies to broadcast licenses. That's been the justification of all of those decisions. Is the spectrum scarcity and lesser scrutiny permits a greater degree of government control. So those decisions, because scrutiny applies here.
Okay, what about the other dozen or 15 statutes that prohibit foreign control that don't have to do with spectrum? Outdated idea of the spectrum.
Well, nuclear waste sites, the government cites a few, those don't implicate First Amendment interests at all. So the fact that the government says no foreign ownership of a nuclear waste site, there's no First Amendment issue in it saying requiring divestiture of it.
So it all depends upon our accepting your view that there is a First Amendment issue here because notwithstanding the foreign control potential, we have a U.S. speaker.
I think that's right, Your Honor, and I think that's a fundamentally important.
Can I just ask about the broadcast idea? So if we're in the land of allocating broadcast spectrum space, and the rationale for not allowing foreign ownership in that context is we're worried about foreign ownership begetting foreign propaganda. Would that, in your view, be something that needs to be justified by strict scrutiny? If that's the rationale is we're not going to allocate this slice of spectrum to either foreign control or an entity that's subject to foreign control. That seems to be fine because that's what the law does and it's been sustained. But the rationale for that is it's because we're worried that if that happens, it'll beget foreign propaganda.
I think if that's the justification, strict scrutiny might well apply. There might, again, it might be satisfied because of the scarcity rationale that also applies. But I do think once you get into viewpoint basis, I mean, even in Holder, the court said, you know, very targeted speech, a very targeted congressional restriction. The court said strict scrutiny applies. This is a restriction.
But the speech that was at issue in Holder wasn't foreign speech. I mean, it had implications abroad, to be sure, but what was going on was it was lessons that were being taught. There wasn't a question about an analysis being different because what was being targeted was foreign control, or even foreign adversary control. That obviously.
Yeah, I just think, Your Honor, if the premise of a lesser standard is foreign control, then surely the foreign control has to be demonstrated by some strict scrutiny standard because you're then taking away the rights of the U.S. speaker. So if the premise of applying a lesser standard is foreign control, I think you're still in strict scrutiny because the consequence of that is totally taking away the First Amendment rights of the speaker, and the government really doesn't argue that. And I really want to draw a distinction between foreign ownership and foreign control. I think foreign ownership, for the reasons I said in our colloquy before, would be a pretty shocking change here. Just to go back to Judge Rao's question for a minute about disclosure, I think disclosure has been the historic answer for covert content manipulation. That's what the statute at issue in Mies v. Keene talked about. Just identify the source, and then Americans can make the choice. That's exactly what happened. Again, I'm not saying there might, in some hypothetical world, be possible in some situation to say that that doesn't work, but that's certainly been what happens. And we're not saying that covert.
How do you identify covert influence in a code that they estimate, you know, like the source code, they say it would take 3 years to just review the existing source code?
Well,
much less any updates to the code. So how are you supposed to have disclosure or verified disclosure in that sort of circumstance?
Your Honor, it might be that the disclosure is just the risk of that the government says there's a risk of control. Maybe the disclosure doesn't have to be targeted. I don't know exactly what it could be, but again, we haven't had any exploration here of even if there is control on a record that this court can review, let alone whether disclosure could work. Maybe the government would come up with some arguments that it wouldn't work. I don't think they could. But let me turn for a minute to News America, because I think that really is a root and explains the problem here. I mean, News America was a case where the court said this statute, even in the broadcast context, targets a specific speaker. We therefore are going to apply heightened scrutiny. And we don't see any reason why Congress exempted this individual speaker from the general rule about when you can get discretionary waivers from the FCC, and therefore we're going to invalidate a prohibition on that. And this case seems to us to be on all fours with that. Here we have a specific U.S. speaker targeted. It's been exempted from a general process that answers a lot of the conundrums that are before this court. What about less restrictive alternatives? What actually is the basis for alleging government control? Here's a record. Here's a reasoned decision that can be reviewed. And then this court can review it. We'd have a lot of the same legal arguments, but part of the issue in this case, and we think it's a constitutional flaw, not just a problem, is that Congress didn't do any of the things that the First Amendment requires.
Mr. Pincus, I mean, if I understand, of course, you think strict scrutiny applies, but assume for a moment that O'Brien is the framework and intermediate scrutiny applies. What is your best argument that ByteDance, TikTok can win under that level of scrutiny.
Well, we still think under intermediate scrutiny, there's a requirement to look at alternatives, and there's no indication that Congress looked at the alternatives here. There's no indication that
Well, there's
disclosure-
alternatives, but it doesn't have to be the least restrictive means.
But they have to be considered, but they weren't even considered. And I do think, going back to sort of a broader problem in this case, we have a real threshold question about.
So you're not challenging the government's interest as substantial under intermediate scrutiny, just the tail.
No, I am challenging the government's interest in scrutiny. That's what I was about to say, is that the government, as I said, has plucked out this very targeted interest. But I think if you look at what Congress talked about, the problem here is that there was a lot of discussion about content, the imbalance of content on TikTok at times where the government concedes there's no foreign manipulation whatsoever. And I think figuring out what Congress's actual purpose was here, that's the test that the Supreme Court has set up in First Amendment cases, it is very problematic because we really don't know. The government is defending this very, very narrow, or arguing that it's this very, very narrow interest here, but the record is suffused with comments by legislators, both in the House and Senate, about the supposedly imbalance about Palestinians and Hamas, all kinds of current events. Now, we have Mr. Weber in his declaration explains why those allegations of imbalance are wrong, but they clearly motivated Congress in a significant way. It's another reason why the availability of the general standard and the real tainted problems with the specific TikTok provision sets up an alternative where if the government thinks that it can establish a record based on the argument that it's sort of culled together, let it put together that record, look at the less restrictive alternatives that have not been addressed, and also, frankly, consider the facts. Another sort of issue in this case is to rule for the government.
Like you're arguing for us to remand without vacator to Congress for more
Well,
findings.
I don't think.
It's a very, very strange framework. I mean, I know Congress doesn't legislate all the time, but here they did. They actually passed a law, and many of your arguments want us to treat them like they're an agency. It's very strange. It's a very strange framework for thinking about our first branch of government.
I think it's an unusual law, though, Your Honor. It's a pretty unusual law, an unprecedented law, as far as we know, that specifically targets one speaker. We can't find, and bans generally. This isn't Kaspersky or one of these laws that talk about government procurement or the use of government funds. This is a law that broadly regulates and targets that regulation at one speaker. That's pretty unusual. And I do think News America supplies the paradigm. Now, in News America, the court didn't say we're remanding to the FCC, but the functional effect of its decision was to say the FCC will apply the general standard, and then if there's a problem, we'll figure it out. So I'm not saying remand to Congress. I'm saying exactly what the News America court said.
It's a rather blinkered view that the statute just singles out one company. It describes a category of companies, all of which are owned by or controlled by adversary powers, and subjects one company to an immediate necessity because it's engaged in 2 years of negotiation with that company, held innumerable hearings, meeting after meeting after meeting, an attempt to reach an agreement on a national security arrangement, which failed. It's the only company that sits in that situation that is so advanced in its negotiations and its relationships with the government that it's exhausted any further possibility of relief through the second procedure.
Well, respectfully, Your Honor, I guess I'd have two answers to that. One is,
as usual, Mr. Pincus.
Sorry, I just want to give the court multiple reasons. The generally applicable standard is more protective for companies. It gives them a statement of reasons for this court to review. It has the business review exclusion. We can debate about what it means. Maybe it's broad and it says.
Maybe so, but you're not making the claim to have that exclusion.
Well, it's not an option for us. If we were in that generally applicable standard, something that's certainly possible, there's a lot of review content on TikTok, business travel product reviews.
And you can come back, I suppose.
I don't think so, Your Honor.
Maybe
because
not.
The statute is an absolute bar. Other companies could say.
It's an absolute bar on the current arrangement of control.
Yes, but under this generally applicable standard, that arrangement of control won't be disturbed if there is, if the exclusion applies. So that's something that's not available to
That's
us.
essentially your equal protection argument, correct?
No,
Equal protection heightened with a sort of First Amendment flavor enhancer.
exactly the argument that was in News America, Your Honor. What the court said is we're looking at the First Amendment equal protection with a little flavoring of bill of attainder.
Since we're talking about levels of scrutiny, which I'm not sure we should have wasted all this time on, frankly, or used all this time on. There's certainly there's no precedent, no case going either way involving a designated adversary nation. Surely that might have something to do with the level of scrutiny that a court should apply to a judgment by the Congress about a foreign power.
I think that the issue, I think
A
that
level of
might,
deference, let's say. Go ahead.
I think that might apply at whether strict scrutiny is satisfied. But as I said before, the problem here is the predicate isn't just, this is not claimed to be all the speech of the designated foreign adversary. Maybe that would be a different situation. Might not be, but we don't have to decide that. What's claimed here is there might be some influence on this fully protected U.S. speaker in the future, and therefore we can burden the fully protected speech now. So the predicate control is what the government has to establish, and I think our argument is it has to meet a really high standard to do that, because what it's doing is taking away the rights of an American speaker.
You're quibbling with whether there's actual Chinese potential control that the company could not be directed to do something or refrain from doing something?
I think that is one of our arguments, yes, whether it's possible and
Under
whether the
Chinese law.
protections.
That's your interpretation of Chinese law?
Well, I don't think the government claims Chinese law can do that. I think their claim, I may be wrong, is mostly related to the data privacy part of the equation, but I think that our conclusion is.
They argued flat out that being subject to Chinese control, the company, it's a misfortune perhaps for the company, would have to and would certainly comply with a requirement with respect either to content manipulation or to hoovering up information.
I don't think the government has established that yet. We haven't seen what's in the confidential secret submissions, but I don't think they've established it even as a matter of Chinese law. But even if they do, I think then the question is, do these two justifications apply, or is there some less restrictive means? And that hasn't been decided. It was a question even in Holder, that was an issue.
Let me make sure my colleagues don't have additional questions for you, because we still have to hear from the users, and we'll definitely give you some rebuttal time. But we'll give you rebuttal time, Mr. Pincus. Thank you. Mr. Fisher.
Morning, may it please the court. The creator's fundamental submission in this case is that wholly independent of TikTok and the company's interests that are at play here, the act here directly implicates the First Amendment rights of American speakers to speak, associate, and listen to free expression in this country. Any other holding would prevent American writers from publishing in Politico or Al Jazeera, would prohibit American musical artists from posting their music on Swedish-owned Spotify, or would prevent American filmmakers, allow Congress to prevent American filmmakers from creating documentaries to be edited and aired on the BBC. Our arguments on the compelling interest and narrow tailoring side of the case do parallel TikTok's to a great extent, but I do want to emphasize that the government's content manipulation rationale is wholly illegitimate and invalid and anathema to the First Amendment, and it itself taints the entire act. If you could, as Chief Judge Srinivasan hypothesized, isolate just the data privacy, that itself would also be not a compelling interest and not narrowly tailored. Taking a step back, it is truly striking.
What is the creator's interest in that aspect of the case?
In the data privacy aspect of the case? Yeah. Well, the creator's interest here is the First Amendment right to publish and coordinate with their publisher of choice, as in the net choice sense of TikTok. And so if you work all the way down through strict scrutiny to the government's purported interests, we think the data security interest is invalid for a couple of reasons. And I can walk through
We're talking about the concern of the government with with hoovering up all the information about American users, including your speakers. Right?
Right. So we just think that is an insufficient justification to satisfy certainly strict scrutiny, and even if we were in a world of intermediate scrutiny, and for a couple of reasons. One is, as the company has elaborated in its briefing, the government's arguments themselves are overblown. Geolocational information is not gathered to the extent the government asserts. Contact lists are not given to the company unless the users opt into that. And in general, there's a real problem with the government's data security argument, particularly from my client's standpoint, because those are voluntary acts. These are opt-in procedures to share your data if you wish. So that's the first problem. The more dramatic problem, though, if I could really emphasize this, that even if you could isolate data security under the Arkansas Writers Project and Minneapolis Star cases, that would have to be subjected to strict scrutiny because you have a law that is singling out speakers, that is singling out media and the press in the way that triggers strict scrutiny in those cases. And there's no way, if I could just add one quick thing, and I want to answer your question, there's no way that can satisfy strict scrutiny given all the exclusions Mr. Pincus has described with e-commerce and all the rest.
So the opt-in for sharing your data, the users ask, do you want to share your data? That doesn't mean sharing it with ByteDance, right? The problem is ByteDance is going to have, or TikTok's going to have the information. The question is, do you want us to be able to share it with others? Is that correct?
Well, I think that, yes, you understand you're sharing your data with TikTok and public information, who TikTok is ultimately owned by, is a company called ByteDance. And so it's wholly voluntary on the user's part. But it's really the under-inclusivity in a world of strict scrutiny, which has to be applied under Minneapolis Star and the Arkansas Writers Project, that sinks the government ship on the data security side.
Mr. Fisher,
it can't be, yeah.
Does your argument depend on a conclusion that divestiture is impossible?
No, it doesn't. So I think it is, it seems like the record shows that it's impossible, and I'm not sure how much the government pushes against this, but even if it were possible, for two reasons.
So what would be the creator's interest in TikTok US being owned by ByteDance?
Well, our interest is in working with the publisher and editor of our choice, including the current ownership, which works very well for our creators. You couldn't tell an American writer that they wouldn't have a First Amendment interest in working with Twitter owned by a particular individual, or if Fox News was required to divest from Rupert Murdoch.
Do you have a First Amendment interest in who owns TikTok?
Yes, that is who the publisher is, ultimately, you could say. And so the act directly singles
Doesn't that argument bolster the government's argument, though, that TikTok US is controlled by a Chinese headquartered company?
Well, I think that you have to walk through this step by step. So you've asked, do we still have a First Amendment interest in a particular owner or publisher? Absolutely, yes. No case that I'm aware of has ever suggested that singling out a speaker or publisher does not implicate First Amendment.
But a lot of the argument depends on TikTok US being a separate corporate entity. Right.
I think a lot of the argument does depend on it, particularly
so it
from the
remains a separate entity. It just its ownership changes.
No. But I want to emphasize, even if I would spot the government all of that and say all the way down to control, which we don't think is in the record in this case, we would still have a First Amendment interest of working with whatever foreign owned publisher we want. And all the hypotheticals I've just given you, from Politico to Al Jazeera to Oxford University Press, all the way down. And I want to emphasize, Judge Brown, this goes to Judge Ginsburg, you asked about foreign adversaries and foreign governments. There are absolutely Supreme Court cases, Lamont and Whitney, first and foremost, that hold that even American speakers speaking in conjunction with foreign governments who are hostile to this country. That is the holding of Lamont.
So in the broadcast context, then, would you say that there's a First Amendment interest in making sure that broadcast spectrum is subject to foreign control if there are users who would like to work with the foreign controlled license?
I think the way you were describing in your back and forth with Mr. Pincus got it right in the end, which is simply saying rules about foreign ownership simpliciter are okay as a matter of the First Amendment. But if the government were sorting between viewpoints, even as according to who is more hostile to this country or their views of communist nations, again, that brings us right back to Lamont. It brings us right into Whitney. Remember, the speaker in Whitney was a member of the American Communist Party working in conjunction to espouse the Moscow principles laid down in the manifesto that Justice Brandeis describes.
So then if that's the relevant distinction, then it's not enough for the government to say in the broadcast context, we're just going to exclude foreign ownership, period. You'd say, well, you have to explain why. Why do you want to exclude foreign ownership? It's not enough for you just to say you want to exclude foreign ownership and then win on that basis, because if the reason you want to exclude foreign ownership relates to a concern about the content implications of the foreign ownership, then that might not be permissible.
Well, look, let me just give a quick preface and then give you your answer. I don't want to get too far into broadcast because ACLU versus Reno makes very clear that the world of the internet and the unlimited marketplace of ideas on the internet is very different from broadcast. But so I think whatever you say here wouldn't bleed over to broadcast.
I'm just trying to
but on the broadcast side, to answer your question, I think that if the government came in and said, we're worried about the viewpoint of the speaker, not just the foreign ownership, that would be a problem. It would be something that I don't think the US Supreme Court has ever said that is okay. And as I said,
even though that was, as I understand it, that was the reason from the very beginning, the Communications Act, that was the reason that Section 310 excludes foreign ownership, is a concern about foreign propaganda. Well,
I think that, again, you'd have to trace that back and ask whether that's still the justification today. If that were what happened in the past, you'd have to ask whether the government has other arguments in those sorts of cases. There'd be a lot to sort of work through in that case. But I think it's fair to stand here at the podium and say the U.S. Supreme Court nor this court has never said that content-based restriction, or I'm sorry, viewpoint-based restrictions among foreign speakers is a legitimate interest to pursue under the First Amendment. Mies against Kane, the Supreme Court stressed, and actually Solicitor General Freed in that case stressed to the Supreme Court, that was exactly what saved that law in that case, was that foreign propaganda was described by Congress in entirely content-neutral terms. And so the government didn't even make the argument in Mies against Kane or in Lamont that the government is making here, that a foreign speaker or a foreign government can be suppressed from ownership or speaking or curation or any of these other First Amendment activities based on their viewpoints. But remember, the reason I'm standing at the podium here is that this isn't just a case about a foreign speaker. If this were a case like Lamont, just about foreign speakers and Americans wanting to hear that, I think you'd already have a victory for the American listeners under Lamont. And certainly no Supreme Court case has ever held to the contrary. And there's no history and tradition in our country of banning US speakers from hearing from foreign governments, even if they're hostile to our country, simply to express their ideas. But that's not even this case. This case is American speakers like the creators and like Base Politics who want to speak to other Americans on an American platform, and at the very most can be alleged to say they want to coordinate with a foreign publisher when they do so.
Can I ask about Lamont? So if we look at Justice Barrett's concurrence in that choice, it clearly presumes, in her view, that foreign control changes the equation under the First Amendment. And if that's so, is Lamont always a trump card? Can Lamont just always kick in and say, even if there's an ability to deal with foreign control vis-a-vis the foreign speaker, because the foreign speaker doesn't have First Amendment rights, it turns out that that's going to be an illusory ability on the part of the government, because you can always bring into play the US recipients and their rights kick in.
So let me start with Justice Barrett's concurrence and explain how this all sorts out. So really all she said is foreign ownership might change things under the Open Society case, which is true as far as it goes. It's a question to ask, a fair question. But I think the way I distinguish Open Society on the one hand and Lamont and all the things I'm describing on the other is Open Society is just about a foreign speaker speaking abroad. That's what that case is about, full stop. And there is no First Amendment interest in foreign speakers speaking abroad. But once that speech is directed into the United States, and certainly once that speech is in concert with other Americans and indeed propagated by other Americans, the speech on TikTok is not Chinese speech. It is American speech that at most is curated by a foreign company, and the government says potentially by a foreign government as well. But it's American speech. You're way, way, way on the First Amendment protective side of the equation, and we're even have a much stronger case than Lamont. So all Justice Barrett, I think, is saying in that choice is, oh, let's ask that question if and when it comes up. But when you have speech inside the United States, our history and tradition is we do not suppress that speech because we don't like the ideas. If I could just give one more example.
Would that apply in wartime too, just to continue the hypothetical? I'm curious about your reaction to that. So if the rationale for this for barring foreign ownership of a media establishment is a concern about what that is going to produce vis-a-vis content, and we're in a time of conflict with a foreign adversary, would you say that the U.S., there's definitely, I mean, protest here against a war is completely protected under the First Amendment, and so that viewpoint would be one that American listeners might well have an interest in hearing a lot about. Would you say then in that situation, because of clients like yours, the American recipients, that a bar on foreign adversary ownership of a media establishment during war is invalid?
Leaving the broadcast question aside.
Yeah, aside from broadcast.
Definitely strict scrutiny would apply, and I can imagine particularized facts where strict scrutiny might be satisfied in the heat of war, depending on what exactly the content of the speech is. But in a situation like this, where we're not at war, and all we're talking about is so-called foreign propaganda, really, again, arranging American speech.
But the negative predicate of that is even in war, you wouldn't just accept that the government can prohibit foreign adversary control,
As I say, that might be the case, but I think let me give you a couple of historical examples to show why even that is a very hard question. George Washington, in his farewell address, one of the central themes of that farewell address was beware of foreign influence. Remember, France had supported Thomas Jefferson in the election, and George Washington told Americans, beware of foreign influence, and be careful about foreign influences, and be careful about making your own associations with foreigners. Never did he suggest the answer was to suppress foreign speech. Look at FARA, the statute passed in the run-up to World War II. That was at issue in Meese against Kane. Congress there dealt with foreign agents in the U.S. spreading foreign propaganda in a run-up to war. And that law, all it does is require disclosure. It does not prevent Americans from, as the government in its most robust form of the argument would say, creators like the ones on TikTok do. And then Lamont, again, in the height of the Cold War, again and again in our history, we have this. And Judge Rao, you also asked about the Palestinian, the PLO case.
I'm interested. That case seems very similar because there you had American citizens who associated with the Palestine Information Office.
Right.
And our court said, requiring that office to disband was only an incidental burden on their speech because they could continue speaking about Palestinian causes in other fora or even form other groups. They just couldn't be a foreign mission of a terrorist organization.
Right, so I think you stressed the important part about that case, which is distinguishable from here, which is my understanding is the court there stressed, we're not suppressing any speech here at all. We're just preventing them from having this mission in this office, but they can still speak.
Why is that not analogous to what's happening here, right? The Congress has decided that TikTok US cannot be owned by effectively a Chinese corporation. And so that leaves creators that you represent free to continue speaking on TikTok US if they divest, or on other platforms, or create a new platform, or any number of other ways they could continue, sharing their content.
Right, so remember, I think the facts would show that divestiture is impossible, but leaving that aside for the moment.
But you said that your argument doesn't depend on
it. It doesn't, so let me I just wanted to put a pin in that. So there's a couple of big differences between what you're describing in this case. So the first is that there are not interchangeable mediums for our clients to speak on. And I don't think the government seriously dispute the declarations that show that TikTok is unique in terms of how it looks and feels, the audience that people are allowed to reach. So one of our clients, reaches millions of people, has millions of followers on TikTok, has tried to work on other platforms. 10,000 or even fewer than 100 on YouTube are able to. So there's a whole different audience that you wouldn't have had in that case. You have whole different tools available, like CapCut and editing tools. So the nature of the speech is different. In the PLO case, I think you would have still been able to exercise all the same, expression. And reach the same audience.
But you wouldn't, one of your arguments is that the creators want to work with their foreign owner publisher of TikTok US. Arguably in the Palestine Information Office case, they wanted to work with the PLO and to represent the PLO in America. That was the whole mission of that office.
But I don't
maybe the interest in the Palestinian case is actually stronger.
So I don't take that case to say that speakers going forward there would not be able to speak in conjunction with the PLO in the United States.
But they can't represent the PLO.
Well, I think I'm maybe
Well,
going to get too far into
yeah.
the details, but in this case, our first and foremost argument is we're American speakers.
Okay, so it is adjourned until September 19th at 9:30 a.m. Trying to find where this is. Okay, I had to find where that was playing. There we go. All right. So that was just another channel when I was opening channels, trying to find that hearing. So there you have it. Just as I expected, the government has very extremely weak arguments. They do not want to go to strict scrutiny because strict scrutiny would mean that they would have to actually justify their reasoning for banning TikTok. You're off for the day. What, Wolfie? You got to plant flowers and now you're off for the day? That's amazing. Yeah, I haven't even gone outside to start my day. I was sitting here listening to our government's BS. Merrick was so weak. He was so weak, Wolfie. I don't know how much you heard of that, but that's what I expected. Yeah, I know. Salary works that way, but also they can overwork you more than 10 hours and you still get paid. But city jobs tend to be really good. Yeah, they tend to be really good. Do you agree, Wolfie? His arguments were Merrick was horrible. That's what I find so many times. Yeah, it is worth it. I find so many times that our attorneys that work for the government are just lazy and weak, right? He has been a lawyer for a long time, Attorney Merrick. He is 71 years old. He's going to be 72 years old in November. He has been an attorney long enough. Well, put it this way. He's been an attorney long enough to know that they usually get away with their weak arguments. So it takes smart attorneys, like you heard. The attorney for the users, he's good, you guys. He's good. He just kind of let Merrick run his time down on BS. And then he came back in with a strong argument and he ended the day with his rebuttal time with a strong argument. Because Merrick tried to get away from strict scrutiny. Why? Because strict scrutiny makes government butt out unless they can prove. And even a national security interest does not just give them carte blanche to run over your First Amendment rights. He's trying to make it sound like this is something that the government has to interfere with because they're afraid of future control of a foreign entity. And that's just not how our law works. That's just not how our government works. So government security is completely separate from our court system. And they don't like when they have to confront the courts, right? Because they can't just do what they want. They can't just know the American people. That's what they're trying to do. They're trying to trick the American people into thinking that there's some kind of manipulation going on with them that they can't prove. And they're trying to say they can't prove it because they can't see the code. But, you know, it's so sad. Too bad. It's just like anybody else's case. If you don't have the proof, get out of the door, Jack, right? Walk. You're out of here because courts work on evidence. Merrick had no evidence. That's what I was listening for. I knew they wouldn't. All of those Senate hearings, congressional hearings, they had no evidence. And their excuse was, we don't have to show evidence. Okay, they're right. When Congress is passing an act, they don't. But that's why we have our separate branch of government, which is our judicial branch, that is part of our checks and balances to say, okay, if somebody brings a challenge to us, we are now going to hold you to that criteria, to those standards. And the reason for that is actually to control our own government, you guys. Our own government is trying to violate our rights. That's what this case is about. They're trying to divert you and make you fear China. They're trying to divert the issues and hope that they can use those smoke screens to violate your rights. And if they get away with it there, they'll go on to the next thing and the next thing. And next thing you know, it might be your company. Because don't even think that they will just stick with foreign companies. They use that to make inroads into controlling you individually here in this country. Right? So that's why I'm interested and I watch. Anytime it deals with violating anybody's rights, you guys, anybody's rights, you're at risk. That's the way it works. Right, Wolfie. There are a lot of Chinese-owned news sources in the U.S., right? There are a lot of Chinese-owned businesses in the U.S. So where do they stop? And if they're not held to standards in the courts, then we have no checks and balances, and then we will have no way to prevent our government from running roughshod over our rights. Okay? It is our right to be protected from this kind of behavior. So that's really what this battle is. This battle is about our government trying to violate our rights through the back door and then turn around and say, we're going to use this case as precedent. That's what they'll do. If they get away with it here, they will then use this case as an example in the next thing. It could be with a U.S. owned company. So they're just trying to make it easy so that they don't have to keep proving strict scrutiny. If they can get away with it, they'll just go from case to case to case, and they'll have an easier time violating your rights. So it's very important that you get involved, and that attorney that is representing the users, if I were you, I'd get in touch with that attorney, support that argument that he's making. And even if you're able, I would say donate to him, so that they can keep their fight going, so that they can afford to continue their efforts. He made good arguments. You guys. So the court has adjourned until September 19th. September 19th. That is going to be this Thursday. 9:30 a.m. Oh my gosh, I have to get up early again, Wolfie. What? Twice in 1 week. We just say land too. A lot of Kansas farmland is held by Chinese owners, just sitting there waiting for someone who wants to expand on it for those big money. Yep. Yeah. I know, right, Wolfie, right? Yeah. Okay, well, thanks for coming, Wolfie, and listening to me rant on this. It's been 2 hours and 18 minutes and 59 seconds. So 6 a.m. and being ready by 8 a.m. Oh my gosh. It takes you 2 hours. What the heck? All right. So I'm going to go and check on my chicken since I'm up. What is it, 11:13 now? And then I might come back and stream a couple of products or make videos on it. I haven't decided yet, just to get them off my list. So you guys can find me in the Discord server. If you do not have that, let me give it to you here real quick. Who else is in here? It says 2 people are in here. I'm going to give you the link to our Discord server. You can jump in there. That's where I hang out when I'm not on TikTok or YouTube or Facebook. Let's see, I'm trying to get the link. Hold on, I gotta expand it. There we go. That is not what I want. Oh. All right, so I'm gonna grab this link. Invites. Why does it keep having me create new ones? All right, got it right here. I don't see a link. Enjoying the morning sun. Weren't you already out there in the morning sun? There's the link right there. So it's good for 7 days. Grab it up, you guys. Whoever the other person is in here, that's our Discord server general chat. You can jump in there and continue the discussion if you would like to do that. Yeah, I put it on my Facebook too. So I don't know. I think this chat stays. This chat stays even when I'm not live anymore. All right. I'm out of here, you guys. Thanks for coming, Wolfie. Bye.